Well, good morning, good afternoon, everyone. Welcome to a 90-minute webinar on the Alberta Tailings Ponds 2 factual record, a submission under the NAFTA Environmental Side Agreement. My name is Paul Babelis, and as Sustainability Network ED, it's my pleasure to welcome you all here today. Sustainability Network is a Toronto-based nonprofit capacity builder. We help environmentalists and environmental NGOs across Canada lead, manage, and strategize. I want to start with a land acknowledgement and recognize that we here in Toronto are in the treaty territory of the Mississaugas of the Credit and on the traditional territory of other Anishinaabe peoples, Haudenosaunee, and Huron-Wendat. And although we're at locations all over North America and beyond, I'd encourage you all to just take a moment, pause, and reflect on whose land you reside. You'll all be muted through the call today, but we want your questions. So please use the Q&A function and submit questions as they come to you. Sort of beat the rush and please submit questions as they arise. A special bit of housekeeping relates to the interpretation function. Each and every webinar participant needs to go to the interpretation function on the bottom functions bar, and on the far right, a two-step process. One, select your language of choice, and two, mute original audio. Again, everyone on the call must do this two-step process. Interpretation, pick language, then mute original audio. Please use the chat room to get a hold of Laura, my colleague, and she can help you with any technical difficulties, including the language selection I just mentioned. So we have over 200 people registered for the webinar today, numerous environmental NGOs from our subscriber list, but also industry and government, predominantly from Canada, but also from US and Mexico as well. Welcome to everyone. Finally, a note that a recording of today's session, along with the slides, will be sent to you by the end of the day. So without further ado, let's start the session. We'll first have the 5 panelists make 10-minute presentations on their perspective or speciality, and then I'll select from among the questions you submit and facilitate a follow-up discussion. So our presenters, Paulo Solano is Director of Legal Affairs and Submissions on Enforcement Matters at the Commission for Environmental Cooperation, and will outline the submissions process. Martin Olszynski is an Associate Professor of Law at the University of Calgary, and his comments will relate to his primary research interests: environmental, natural resources, and water law and policy. Jonathan Martin is a professor of toxicological and environmental chemistry at Stockholm University in Sweden. He's also an adjunct at the University of Alberta, where he continues to study air and water contamination around the Canadian oil sands industry. Dale Marshall is the National Climate Program Manager for Environmental Defence Canada, and will present an environmental NGO point of view on the oil sands. So our final speaker will be Melody Lapine, who is Director of Government and Industry Relations at the Mikisew Cree First Nation in the Fort Chipewyan area of Alberta, and is responsible for overseeing consultation pertaining to resource development within the Mikisew Cree territory. So first over to Paulo, of the Commission for Environmental Cooperation.
Thank you very much, Paul. I'm going to go ahead and share my screen, and I hope everyone is able to listen to me and follow my remarks. First of all is this. So I'm going to give an overview of the CEC, of the Commission for Environmental Cooperation, the submissions process, give a really introduction to the Alberta Tailings Ponds submission and factual record, and finalize with some of the numbers and statistics on this process. So the Commission for Environmental Cooperation was created by the North American Agreement on Environmental Cooperation almost 25 years ago, in 1994. It is created by 3 states, by 3 countries: Canada, Mexico, and the United States. The Commission for environmental cooperation, the CEC is composed by three permanent bodies: the Council, the Secretariat, and the Joint Public Advisory Committee. The Council, which is composed of cabinet level members charged with the environmental agenda in the respective countries, is also the governing body of the Commission, and it authorizes the budget and it authorizes the annual work of program. The Secretariat, which is based in Montreal, implements the trinational cooperative agenda and also implements the submissions on enforcement matter process. JPAC is a body composed by, now composed by 9 members, 3 from each country. Originally was created by 15 members, 5 from each country. In 2020, the North American Agreement on Environmental Cooperation was replaced by the Environmental Cooperation Agreement. It entered into force in July 1st, 2020. Now, the major change here when the ECA came into force is that the submissions on enforcement matters process, which we'll be talking today, is now under the USMCA CUSMA Chapter 24. I will be referring to CUSMA or USMCA because it's how it's referred to in Canada and the United States. In Mexico, it's referred as TMEC. A very important note is that this factual record and the submissions that were active until July 1st, 2020, are still governed under NEAC, are operated under the old regime, the old agreement, and so is this submission and factual record that was recently published. So what is this? What is the SEM? What is the submissions on enforcement matters process? Is essentially it's a transparency mechanism which is focused on the effective enforcement of environmental law. The aim of this process is to promote accountability and effective enforcement of environmental law. This is a non-jurisdictional, is non-adversarial mechanisms, and the production of a factual record ultimately allows the public to reach its own conclusions. The factual record itself does not contain a conclusion of law or a recommendation for a party to conduct a specific action or to take a specific step in a definite direction, but more it provides the information to the public so it can reach its own conclusion. Here, I mean, this diagram basically presents the steps of the process, and I am going to exemplify the process with the Alberta Tailings submission. So on June 26, 2017, the submitters, Environmental Defense Canada and the Natural Resources Defense Council, along with a Canadian resident, Daniel Tassili, filed a submission with the CEC Secretariat. The main assertion of this submission is that Canada is failing to enforce subsection 36.3 of the Federal Fisheries Act, of the Canadian Federal Fisheries Act, which we will be addressing later by Martin Olszynski will be addressing later today. So the main assertion is that this failure to effectively enforce is related to the leakage of a deleterious substance from oil sands operations into the surface waters that are frequented by fish, or through groundwater and the surrounding soil into surface waters frequented by fish in northeastern Alberta. The Secretariat issued a determination allowing the submission and requested a response from the government of Canada in November 2017. Canada advised that Environment Climate Change Canada has undertaken proactive inspections between 2019 and 2014. Canada provided information in that respect, and advised that these inspections are, as well as other ongoing efforts regarding research, constitute an effective enforcement of environmental laws. These inspections ended in 2014, and basically Canada returned that's what Canada informs in its response, that it returned to a reactive enforcement approach that Canada defines response to basically response to incidents that occur and to information received from the public. So with the submission and the response from the government of Canada, the Secretariat made a determination that it warranted the development of a factual record. And the council voted in favor of development of the factual record, and notwithstanding it didn't address all the areas that were warranted by the Secretariat's recommendation. I must say, and I must recognize, that the government of Canada supported the same process in voting in favor, although with a limited scope than originally recommended. The factual record was, following this voting, the Secretariat proceeded to conduct site visits, interviews, information gathering process. It retained experts in legal and technical areas, and it finally came with the draft factual record, which was presented to the parties, and it was finally voted in favor of publication for its publication on September 20 on September this year. The factual record is publicly available. It can be downloaded. It can be downloaded in the 3 official languages of the Commission. So what are basically with the steps of the process that existed under NEAC remained essentially the same. Article 14 and 15 of the North American Agreement on Environmental Cooperation remained with no substantive changes. Mostly this process is now inside CUSMA, inside the USMCA Chapter 24, the Environment Chapter. These processes continue to be implemented by the CEC Secretariat, and the Council will be still voting for the development of factual records. There is an interesting feature in Chapter 24, which is the creation of Environmental Committee, which is a body created or constituted by representatives from the trade and environmental agendas in the respective countries. The function or the role of this committee is to oversee the implementation of Chapter 24. So there will be an interesting interaction between the Environmental Committee and the CEC. Chapter 24 also came with a couple of novel aspects, which is it allows for follow-up to factual records by the follow-up reporting from the party in question. It also allows the Environmental Committee to issue recommendations to the Council in order to undertake a cooperative program under the CEC. These steps didn't exist under NEAC, and we see this as an important step towards at least closing some of the circles and after publication of a factual record. One aspect that is included in the new agreement is a narrowing of the definition of environmental law, which today only under USMCA only includes federal law. So that we'll see how this develops. And also there's an interesting change in the reduced timelines applicable to the Secretariat. So that will be important in terms of timeliness of this process. I'm going to quickly look into statistics and numbers. We received until now 98 submissions, 33 from Canada, 51 from Mexico, 12 from the US. There are 2 binational submissions. We have published 24 factual records, 14 from Canada, 8 from Canada, 14 from Mexico, 8 from Canada, and 2 from the United States. There's basically an interesting distribution of submitters per country. Their top 5 regions of submitters are in Ontario, Jalisco, New York, Quebec, and Mexico City. So this is interesting in terms of where the submitters are coming from. Also, there's information basically to show the number of submissions per quinquennial. There's been a slight decrease in submissions in the last few years. We will see how this develops under the new USMCA. One interesting aspect of the timeliness effect is that after the council decided to include timeliness in the process, it led to a decrease in the timeliness required in the time required to assess and develop determinations related to submissions. So and you will see that the most of the impacts are basically seen when we requested a response and when the secretariat also recommended the development of a factual record. In the case of the council, although USMCA does not have a timeline for council vote, which it had under the former agreement, we expect to see at least the same behavior in terms of voting from the council. One interesting aspect is to mention that in the former process, there was also a vote to publish the factual record. This vote was sometimes delayed because of agenda issues, because of questions that were not present before each minister. So this is now out of the question, because under the new USMCA, there is no the only voting that can be actually happen is a negative vote. So the secretariat may publish factual record after 60 days if there's no negative vote. So with this, I just concluded. There's my presentation. I'll be waiting for your comments, questions at the end of everybody's intervention. Thank you very much.
Thank you very much, Paulo. And just before we move to our next speaker, just a reminder, if you did come in last minute, you need to do a 2-click function on Zoom on the interpretation function on the far right. You need to select your language of choice and mute original audio. That's everybody on the call. And there's instructions in the chat room if you missed any of that. And also, as Paulo mentioned, please submit your questions in the Q&A function. But now over to Martin Olszynski of the University of Calgary on an environmental law perspective.
Good morning, everyone. Everyone can hear me all right? Looking for some confirmation.
All good. All good.
Yeah. Fantastic. All right. So as was mentioned, as Paul mentioned, I'm Martin Olszynski. I'm at the University of Calgary Faculty of Law. And the perspective that I'll be giving today is actually based largely on my role as a consultant on the development of this factual record. So I spent roughly the last 2 years working with the Secretariat in developing the factual record that was published earlier this year. And so in terms of an overview, I'm just going to sort of really provide a high-level snapshot of the submission, the ultimate scope of the factual record, and there was, Paulo referred to that a little bit earlier. I'm then going to zoom in a little bit on the law in question. I think that's my primary value added here, is to explain and for everyone to understand sort of the legal context for the factual records findings. And then I'm just going to really summarize those at a high level, recognizing that Jonathan Martin, Dr. Martin will be exploring those in considerable detail after I'm finished. So as was mentioned by Paulo, essentially several submitters, first and foremost Environmental Defense, made a submission, engaged the SEM process by alleging essentially that Canada was failing to enforce the pollution prevention provisions of the Federal Fisheries Act with respect to alleged leaking of deleterious substances, and specifically oil sands processed water, and so we refer to that as OSPW, from tailings ponds into the sort of lower Athabasca region of northeastern Alberta. And so then, the factual record was ultimately the scope of the factual record that we prepared took some twists and turns over the course of its development and preparation. And part of that was related to enforcement efforts that had been undertaken by Canada. But ultimately, the factual record really focused on these three matters. These were the matters that the factual record was supposed to report on. The first was Alberta's relationship with Canada with respect to the assertions made of non-enforcement. Okay, and so this is because Canada had indicated in its response prior to the vote on whether a factual record would be prepared that it has this relationship with Alberta and that the two governments are working sort of together on this front. The next was the state of publicly available peer-reviewed science on identifying the differences between naturally occurring bitumen and oil sands processed water. And this was necessary, really driven by the fact that Canada was indicating that, there was too much uncertainty, that it had done some analysis in 2014, it had done some inspections, and that it couldn't differentiate between naturally occurring and oil sands processed waters. And then finally, there was reference made to the oil sands monitoring program. This is the monitoring program that was kicked off in 2012 between the federal and provincial government, when it was discovered the year before, essentially, that the monitoring program and regime that had been put in place for the previous decade or so was basically worthless. And so then, before I get into the findings, I wanted to zone back in on the law in question, right? So what is this allegation of non-enforcement about? And so Section 36, sub 3 of the Fisheries Act states that no person shall deposit or permit the deposit of a deleterious substance of any type in water frequented by fish, or in any place under any conditions where the deleterious substance may enter such water. Okay, and I've taken out a few parts just to really focus in on what I think are the operative provisions in this instance. The definition of deleterious substance is defined in the Act, but suffice it to say, and as I'll show in the next slide, that is really the most important part of this prohibition. I do include a reference here. Of course, the opening to 36.3 refers to subsection 4. And so what is this caveat about subsection 36.4? It refers to deposits that are authorized either by regulations under the Fisheries Act or by another act. None are presently applicable to oil sands. And so, of course, that means that if there is a deposit occurring, it would be unlawful. And then, of course, signaling here a little bit, and then there might be time to discuss this more, there are effluent regulations currently being developed, and that became apparent in the course of preparing our factual record. But the scope of those regulations and whether they will address the issue that is the focus of the factual record is not yet clear. And so going back to, again, staying on this law in question for just a moment, I think the thing that's lost, and certainly I see this in the commentary following the publication of the factual record, is this idea that, if we cannot prove that OSPW or, hydrocarbons found in the lake, in the Athabasca River, for example, if we can't fingerprint them back to a specific tailings pond or oil sands operation, that we can't make out the offense in subsection 36.3, and that's not correct, right? So what I'm trying to convey in this slide is that there are two modes of contravening subsection 36.3. So the first mode is where you have a deposit in waters frequented by fish. But the second mode, and the one that I say is particularly relevant and that you want to be thinking about, especially when Dr. Martin is going through his presentation, is that it's a contravention to deposit a deleterious substance in a place where it may enter waters frequented by fish, okay? And so the court in R versus Gibson Energy, this is a prosecution last year in Saskatchewan, sorry, involving the North Saskatchewan River, but in Alberta, it makes it very clear, and the case law on subsection 36.3 is clear, that it is not necessary to prove that the deleterious substance actually enters waters frequented by fish, only that it could have, right? The word is may. May is possibility, not probability. And so the context of, you know, what the excerpt here at the bottom of the slide is just driving back to the allegations in the submission. If OSPW was directly deposited into waters frequented by fish, or if it was deposited in a place that may enter such waters. And so OSPW is currently placed into tailings ponds, which the submitters alleged are leaching into groundwater and surface waters of the Athabasca River. And so then, not to belabor the point, but to really make that clear, these two modes of contravention, again, recognizing that Dr. Martin will be walking through sort of the findings in relation to this kind of diagrammatic representation. So the first way, and the most common way that we establish an offense under subsection 36.3, what I refer to as the first mode, is that you prove that OSPW, for instance, has been deposited in fish-bearing waters, okay? But the second mode is proven if you can show beyond a reasonable doubt that OSPW could enter fish-bearing waters after being deposited into tailings ponds, right? And so the question then really becomes, you know, what does the evidence say about seepage from oil sands tailings ponds in the surrounding groundwater and in tributaries to the Athabasca River? So then in terms of our findings at a high level, you know, this is from the summary. You know, again, I'll zoom in on the middle one first. This is really and what Dr. Martin will be speaking to, that there is scientifically valid evidence of OSPW seepage into near field groundwater around tailings ponds. And that there is at the same time generally less publicly available peer-reviewed science that it has reached into natural surface waters. So some, but less. Quickly returning again to the scope of the factual record, we found essentially no real relationship between Alberta and the federal government, Environment Canada, in terms of enforcement. There's a skeleton, you know, a written sort of architecture that could provide a route or base for like a meaningful collaborative relationship, but we certainly didn't find any evidence of any such thing. And finally, with respect to the oil sands monitoring program, you know, there was reference, you know, again, on this point, essentially contradictory evidence. Initially, Canada raised the oil sands monitoring program as something that it was doing in relation that was relevant to its enforcement efforts, but then stated very clearly, and we have an excerpt in the factual record, where Canada denied that the oil sands monitoring program has anything to do with enforcement. And so I'm going to skip over these in the interest of time, and I'm just going to say, you know, as sort of concluding thoughts on my part, I think that it's safe to say that, you know, maybe just briefly here, the findings in relation to this peer-reviewed literature with respect to seepage are certainly concerning in my view, and at the very least, they justify transparent, comprehensive, and participatory investigation, further investigation into this leaching phenomenon beyond confirmation, I think, and really moving into quantification and qualification. And why I say that needs to be comprehensive and participatory in particular is that at this point, I think communities in the Lower Athabasca region are deserving of some answers, and they need to trust the process whereby those answers are being derived. And so I think it needs to be done in a much more transparent and independent way than it has thus far. So I'm going to turn it over at that point, and happy to answer some questions during the Q&A.
Great, thank you very much, Martin. And I hate to sound like a broken record, but if you're having audio difficulties, please go to the interpretation function, far right on the Zoom bar, select preferred language, and mute original audio. But now over to Jonathan Martin of the University of Stockholm, as well as University of Alberta, on air and water contamination. Martin, I think you might need to unmute yourself, or we're having
you may need to select the language, John.
Right, John, I think you may need to go to that
Yeah.
the instructions I just gave. So select English and then mute original audio.
Can you hear me now?
Now we're good to go.
Perfect.
Yep.
Okay. Okay, we should be set to go. So thanks to you, Paul, and the Sustainability Network for setting up this webinar. It's really a nice opportunity for me to join and see the broader context of this issue, being that legal and social all at the same time. So I look forward to the Q&A. What I'm focusing on is the science. And although I'm joining you from Stockholm, I actually had about 12 years of research focused on this when I was a professor at University of Alberta in Edmonton, where this was about half of my research program, looking at evidence for seepage from tailings ponds into natural water around the Canadian oil sands industry. And during that time, I was fortunate enough to get out into the field and actually stand at the abyss of a tailings pond like this one. And until you do that, until I did that, I really couldn't appreciate the scale of these structures. And just one tailings pond is striking enough, but then realizing there's about 20 of them in the region. And so it's important to keep that scale in mind as I walk you through some of the evidence of seepage in one location. You know, the impact could potentially be very broad on a spatial scale. And so I just want to note that my report was submitted in 2019, April 2019. And so that means most of the literature that I focused on in the factual record was that was available by February 2019. I was given a list of scientific papers to look at, but I wasn't limited to those. I was free to explore any literature, even some gray literature, but I focused on synthesized documents and not raw data. And so this is the issue. It's oil sands process water. This is the medium that's of interest here. And so of course, this water is process affected. It's being used to extract the bitumen from the oil sands. And so the water contains the water-soluble fraction of bitumen. And it's a really complex mixture, so it's difficult to analyze accurately. And this water is toxic to aquatic organisms. And we know from quite a lot of research that it's a group of compounds called naphthenic acids that really drive the toxicity in the mixture. And another important point is that these naphthenic acids are really quite persistent, so that they degrade very, very slowly. A little sunlight and bacteria makes them go away on the order of decades, but once they get into the groundwater, they tend to be persistent as well. I was given two questions. One was, can analytical chemistry be used to reliably fingerprint the OSPW? And what I mean by that is, can I tell the difference between the stuff in the pond and natural sources of bitumen impacted water? And beyond that, really what I think most people are interested in is this final question: has OSPW leaked into groundwater or surface water? And so that first question about the analytical chemistry, I'll talk about that first. And this is one thing that you need to understand, and this is the challenge. This is why so much public resource has gone into developing methods, is that there's naturally bitumen impacted water in the region. And so we don't want to conflate these natural sources with anthropogenic sources. And so here's a picture. I borrowed this from a recent peer-reviewed paper from Environment Canada, actually, just showing the wall of this tributary, and this dark stuff on the wall is bitumen that's seeping into the river. And of course, the river is constantly eroding that wall, so it's grabbing the bitumen and extracting the bitumen. So it's not unusual to see bitumen signals in naturally occurring rivers. Just to give you an idea from a naphthenic acid perspective, in a tailings pond, you might find about 20 milligram per liter of naphthenic acids on average. Sort of the world record for what we find naturally occurring in the region is about 2 milligram per liter naphthenic acids. So we've found groundwater that just is definitely naturally occurring because it's far enough away from the industry. And the concentrations can get pretty high even in nature. In a river like this, we've seen concentrations on the order of 34 micrograms per liter. And adding to the problem is that these fingerprints of naphthenic acids look similar in OSPW, as in these naturally occurring sources. And then each one of those sources has variability. Even within a pond, there's variability. As the water migrates through the groundwater, that signature can change as well. And so, well, in the past, I've spoken for hours about the analytical chemistry, and I won't expose you to that today. Would love to, but I just refer you to the factual record. If you're really interested in the analytical chemistry, it's all written there. I'll point out that I've divided things in the factual record into high-res mass spectrometry, spectral methods, organic and inorganic geochemical methods. High-res mass spectrometry is really essential if you're in the natural environment and you want to differentiate these natural sources from anthropogenic sources, whereas some of these other methods are quite useful still, even if you're just on the site. The industry themselves, they use spectral methods to monitor seepage. But the point I want to take away from this is that no individual method or no individual mass spec method even can on its own be used to confidently assign the source of bitumen-derived organics. But if you have the right samples and you use them in combination with these other geochemical methods, the overall body of evidence can be enough to make an assessment that yes, there is some seepage of OSPW. So it's important not to only consider the analytical method, but also knowledge of the site, the hydrology on the site. Historic measurements on the site can be really important, and spatial trends can tell you a lot. So it's about study design, it's about knowledge, interpretation, with an awareness of certain limitations. And that's all I really want to say about the analytical chemistry. I'll focus for the rest of this on what evidence there is of OSPW leaking into groundwater and to surface water. So first, the groundwater. Just to jump right into it, tailings ponds have contaminated groundwater. There's no doubt in my expert opinion mind that they have. There's a quote from the factual record. This is what I wrote there. There is strong evidence of OSPW seepage into near-field groundwater around tailings ponds, and has been since the first peer-reviewed evidence was published in 2009. And that 2009 study was based on water samples taken in 2005. So I'll walk you through some of that evidence, but it's important to keep in mind that the types of evidence that I use to make that decision. So even with imperfect analytical methods, the critical evidence that I found were spatial trends, so gradually declining concentrations moving away from the ponds, detection of a signal at a location where there was no signal before, so historic measurements, and field scale experiments, actual field experiments right on the sites of tailings ponds. And so this is a nice diagram that Martin showed you. I've shown it again here. And what I want to point out is this, that there seems to be evidence for seepage vertically from the OSPW vertically through the original overburden and even through layers of clay into these quaternary sediments where you can have aquifers. And once the OSPW is in that aquifer, it can move with the flow of groundwater. And generally, the groundwater is moving downhill, okay? And so at the bottom, you have rivers. But of course, between the tailings ponds and rivers or natural systems. Industry does monitor, so they have a number of seepage monitoring wells usually around their tailings ponds. And even if the seepage gets outside this boundary to these seepage monitors, there are means to recover that. And so an interceptor recovery well is one example where these pump the water back in. So they create sort of a vacuum here, and water from all directions will flow and can be recovered. And so most ponds, well, they're designed to leak horizontally. Okay, this actually gives the structure some strength because the wall of the structure doesn't become saturated with water. Okay, and that's known to happen, and there's good seepage collection systems to control that. We're talking about this vertical seepage. And so just walking you through some of that evidence, the experimental evidence is actually a 10 by 10 meter test pond that was set up before South Tailings Pond was filled with OSPW. So it was a small little site right adjacent to it, or maybe in it, it's not clear to me. But they showed vertical migration of the OSPW monitored over 2 years. So it moved 90 centimeters, which doesn't seem like a lot, but groundwater moves very slowly. And so this is significant. It's moving 90 centimeters through clay. So it's important to keep in mind that there is this proven experiment that this can happen for vertical seepage. Okay. We also know that OSPW can be detected outside tailings ponds. So from monitoring real ponds, including Mildred Lake Settling Basin, Muskeg River Mine Tailings Pond, and Suncor Pond 1, there's evidence of the water, reaching seepage monitoring sites or interceptor recovery wells or beyond. And I just walk you through that briefly. So for Mildred Lake Settling Basin, by 2005, it was recognized that the water had moved about 900 meters beyond the dike and up to 2 kilometers by 2011. And that was based on gradual declines of major ions, stable isotope signatures, organic acids by high-res mass spectrometry. But also site history is really important there. There was previous measurements done in the aquifer that showed no impact of bitumen on the water. So that's really important evidence. Muskeg River Mine, here the seepage had moved about 300 meters, or just less than 300 meters by 2010. This was based on declining trends moving away from the ditch, including signals of organic acid, major ions, pH, stable isotopes. In this case, there's no signal outside an outer ditch, so there was an intervention, and it was clear that the water hadn't migrated beyond that outer ditch at that time. And then Pond 1, this is the oldest tailings pond, and we'll talk about it in a couple slides forward as well. But here OSPW can be detected in monitoring and interceptor wells located just above the river. This is very close to the river, if not in the river, this particular pond. And this is based on combined chemical evidence from 2 or 3 peer-reviewed studies, 2 that I reviewed in the factual record and a recent one that appeared this year, which I'll show you briefly. And this particular pond is difficult to study because the dike of this pond is actually in the river. Okay, so these spatial studies are darn near impossible to do. Okay, so that's the evidence for groundwater. Has OSPW leaked into surface water? There's a challenge there because the Athabasca River is a huge river. Okay, so this is the flow of the Athabasca River. It ranges from 177 to up to 4,700 meters cubed per second. And the human mind doesn't work so well to think what a meter cube per second is. So I can put that into perspective for you based on this environmental defense document where it was estimated that 11 million liters of OSPW per day were leaking out of tailings ponds, not even into the river, but let's just assume 11 million liters a day are going into the river. That's a flow rate of 0.13 meters cubed per second. So that if that amount of OSPW is going in directly into the river, it would be hard to detect that. It would be 1,000 to 10,000 fold diluted and very close to detection limits of the best methods. And so it's not surprising that in all the systematic surveys I'm aware of that you don't detect naturally occurring or anthropogenic signals of bitumen impacted water in the main stem Athabasca River. So that's not really the place to look for signals in the water of the Athabasca River. One of the most well-studied sites is this one. So to get to the question, is OSPW entering the river? There's been a lot of studies at this former Pond 1. Okay, so here's a picture from Edmonton Journal. It doesn't even look like a pond anymore because all the water's been drained off. But what you see here is the wall of that pond called Tar Island Dike. It's called Tar Island Dike because it got bigger and bigger over time, and eventually it actually landed on what used to be Tar Island, and that island doesn't exist as an island anymore. The wall is actually covering it. And so those interceptor well and monitoring wells that I mentioned in a couple slides earlier, showing evidence of OSPW, are these ones. I've estimated where these are. I've never actually been to this particular site, but based on peer-reviewed paper that put little dots, I sort of estimated where they are. The evidence for the OSPW getting into the river comes from drive point water samples. So these are where you take a pipe basically and slam it into the sediments of the river, and you sample the water that moves into the pipe. So this is water upwelling from the sediments into the river. And I won't go over all the evidence. There's a lot of evidence. At the time of the factual record, the scientists on these two papers, Frank et al. And Roy et al., described these as likely OSPW affected, and I tended to agree with them. There's pretty good evidence that these were OSPW affected. Okay, but even at that point in time, it was a bit of a judgment call. It was a little subjective. But a new study came out January 2020. Here it is. And with an additional diagnostic tool where they're using two families of organic acids. Here they've sampled the signature in process water and in a number of natural sites. And here are those drive point samples, which resemble the OSPW. So it's this weight of evidence keeps building. And here these federal scientists say that this supports the conclusions of Frank et al. That groundwater affected by OSPW is reaching the Athabasca River at this location. You can also detect signals of bitumen impacted water in tributaries. Okay, so a number of the tributaries which have less water flow, you can detect these signals. And I just point out two of them here in my talk. One is called McLean Creek, and here's a Google satellite view of McLean Creek. And we've sampled here at the mouth of the river on a couple of occasions. Now this creek is known by industry to be a possible site of seepage. They've installed interception pumping wells along South Tailings Pond to prevent migration. But we've found signals that look like OSPW, but they also look like natural occurring bitumen impacted water here at the mouth of the river. What makes it suspicious is the concentrations we're measuring are relatively high. And on both occasions, we measure pretty high naphthenic acids coming out of there. When we do these studies as academics, we don't have samples of monitoring wells or interceptor wells to compare our signatures to. So it becomes a little subjective as to whether this is processed water or naturally occurring. The other interesting site is called Beaver River. This is known to have received seepage from tailings pond in the past. So internal documents from Syncrude state that much, according to this 2008 report. So dams were constructed around the millennium to control runoff and seepage, but even that didn't work, and they had to upgrade those in 2004. So for several years there, it's quite iffy as to how much processed water seeped. We've done some monitoring in 2011. We detected 10.9 microgram per liter at this site, and the highest concentration we've ever measured in a natural setting was this 190 microgram per liter naphthenic acids in surface water in the Beaver River. So really what's needed at these tributaries is high spatial resolution, more frequent coordinated studies. These locations need to be monitored more closely, including parallel samples of the monitoring wells in the vicinity. Like has been done at Pond 1, I think these should be a focus in the future. So to summarize this, there's a mechanism for vertical seepage. It's quite clear around a number of different sites, at least the ones that have been described in peer-reviewed literature. So pond 1, we've gone over. At other known seepage sites, like Milder Lake Settling Basin, the distance between that pond and the river at least gives some opportunity to intercept that seepage before it hits the river. But keep in mind that seepage at many other tailings ponds, I think there's about 16 others, and also the end pit lake, Base Mine Lake, these have never been evaluated in peer review as with regards to seepage. So there's still a lot of questions. Industry reports indicate key tributaries, the Beaver River, McLean, but also some others are sites of concern. And so I just think more focus needs to be on these particular tributaries in the future. And that's all I'll say for now, and I look forward to discussion later.
Great, thank you very much, Jonathan. And you know, a lot of information there, but just a reminder that you'll get the slides and you can pick apart all that great information. Now over to Dale Marshall, who's Climate Manager for Environmental Defense Canada and an ENGO point of view.
Hi, can people hear me? Right. First of all, thank you to both the Commission for Environmental Cooperation for spearheading this webinar and the other organizers of the webinar at Sustainability Network, and as well as my co-presenters. I'm Dale Marshall from Environmental Defense. I'm speaking to you from the unceded traditional territories of the Algonquin and Anishinaabe peoples. So I'm glad that I'm going forth because a lot of what I'm covering has been talked about already. So Environmental Defense, Natural Resources Defense Council, and Daniel Tsele, a Dene individual, we made a submission in 2010 and again in 2017, arguing that in fact, tailings ponds chemicals were ending up in the Athabasca River and that the federal government had not sufficiently applied the Fisheries Act with respect to these violations. Now, as Paolo talked about, CEC is not actually able to come to conclusions or make a ruling on our submission. They cannot say the federal government has failed to enforce the Fisheries Act. But what they do is create this factual record, investigate, lay out the evidence. And so my job now is to take you through those very clear breadcrumbs that have been laid down by the CEC using the evidence that both Mr. Osinski and Dr. Martin have laid out. These are the breadcrumbs. So OSAN's companies' monitoring reports show that the toxic chemicals that are found in tailings ponds, the naphthenic acids, they're getting past their containment systems. There's scientific evidence that these acids, toxic chemicals, are seeping downwards to groundwater. There are elevated concentrations of naphthenic acids in the tributaries of the Athabasca River. Scientific studies are showing that tailings ponds chemicals are likely, as according to the factual record, and now because of the new research, certainly reaching the Athabasca River. And from a legal jurisdictional perspective, Canada has not delegated responsibility to Alberta. So it should be applying the Fisheries Act. It is responsible for enforcing it and for laying charges when it's being violated. So the conclusion to me, the CEC can't come to this conclusion, but the conclusion that I see is that the federal government has failed to enforce the Fisheries Act with respect to tailings ponds, leaking chemicals into the Athabasca River. And this isn't just an issue for fish and the ecological systems that are there. It's also issues for nearby communities, downstream communities, First Nations communities in particular, that are being impacted by these elevated concentrations of chemicals. I'll take you quickly through the history of failed tailings management. So the first tailings pond was created over 50 years ago. And we knew very, very early that there were risks. Back in 1973, a report was put out saying that the oil sands generally provided that created a lot of risks. And then in particular, tailings ponds created social and environmental risks to the neighboring environment. Since 2009, Alberta government's put in a series of what I would call inadequate measures. Most of them violated or ignored. And we're still at a point now where there is not sufficient regulation or management of tailings ponds. In 2018, the Alberta Energy Regulator revealed that the environmental liability from oil and gas production in Alberta could be as high as $260 billion. And about half of that, maybe a little under half of that, comes from tailings ponds themselves. Also in 2018, the federal government ignored tailings ponds as a source of naphthenic acids. Sorry, there's a typo there. When it did a risk assessment of the risk of naphthenic acids to the ecosystem and to human health, they decided to not consider these tailings ponds as a source of these chemicals. Another way that the industry has avoided taking responsibility for its impacts. So what needs to happen now? The federal government needs to prosecute oil sands companies that are clearly violating the Fisheries Act. And remember, as Mr. Lozinski has pointed out, we don't have to prove conclusively. We could actually say that there's pretty conclusive evidence that these chemicals are ending up in the Athabasca. But all there has to be shown, the threshold under the Fisheries Act, is that these chemicals may have ended up in the Athabasca River. And clearly that has been shown. Well, the federal government, and frankly, the Alberta government, should be putting into place a polluter pay system to make sure that it's the companies themselves who are responsible for the pollution, who pay for dealing with this problem now and for cleaning up their toxic mess. So people will say, well, people may say that there are that the oil and gas companies have been struggling since 2014, since emissions went down. Since the price of oil went down. And yet, and then of course, 2020 has been a difficult year for many sectors, including the oil and gas sector. But over the last 6 years, oil sands companies have been doing very well. So back in 2017, and I picked that year just because there was a study that was done that found that there was almost $50 billion in net profits from the big 5 oil sands companies. Just last year, Suncor, just one oil and gas company, made $3 billion in net profits. It also paid out $7 billion in dividends to shareholders, and it spent $7 billion buying back its own shares to prop up its share price. There are 2 reasons why these profits continue to be high. Since 2000, oil production has doubled, natural gas production has gone up a lot as well, and yet the total amount that's being collected in terms of royalties and corporate taxes has dropped, cut by more than half in both cases. So instead of these profits and dividends getting siphoned off, while First Nations face the impacts of this pollution, and governments are left holding the bag, and of course governments mean us, the citizens, we need to be increasing taxes, royalties, and fees on oil and gas companies, and in particular oil sands companies who are responsible for this problem. The current federal government approach, as has been pointed out, its plan is to regulate tar sands, the oil sands companies, and their tailings ponds to allow oil sands companies to treat processed water from tailings ponds and release it slowly into the Athabasca River. Now remember, these are like toxic chemicals. Tailings ponds hold half of the world's 10 most, the chemicals of concern. And there are 11 trillion liters of tailings. And the government solution is to treat and slowly release them into the Athabasca River. We're not in the 1970s anymore, and yet apparently the solution to pollution is dilution. Instead, the federal government needs to work with First Nations to come up with real solutions, both for the leaks that are happening already and for all the tailings ponds and the trillion liters of tailings that are on the land. Because otherwise you're putting First Nations in the really difficult position of having to decide how much pollution is okay for them. The federal government should be working with First Nations and the provincial government to come up with full containment and green chemistry options that don't allow for more chemicals to get into the Athabasca River, to increase the risks for First Nations and the ecosystems they depend upon. And additionally, we know that these tailings create incredible environmental and human health risks. We also know that the oil and gas sector is the largest source of greenhouse gas emissions in Canada. We need to be phasing out this form of energy, especially when we have alternatives. We should be phasing them out over the next 20 years. Clearly, the industry has not taken responsibility for its impacts, and we have ways to serve the needs, our economic needs, our energy needs, without the use of this destructive product. We also need to fully implement the UN Declaration of the Rights of Indigenous Peoples so that they have a say in what happens in their traditional territories, including having free, prior, and informed consent. And we need to develop a just transition plan. There are workers that are going to be affected by this, and there are communities that are going to be affected by the phase out of fossil fuels over the next 20 years. And they need to be taken into account and included in the development of a just transition program. I'll leave it there. Thank you very much.
Yes, thank you very much, Dale. And our final speaker is Melanie Lapine, who's Director of Government and Industry Relations at the Mikisew Cree First Nation. Over to you, Melanie.
Thank you. Just bear with me here to bring my screen up. So first of all, just want to acknowledge that I'm joining you all from the Athabasca region within my ancestral lands of the Cree, Dene, and Métis nations within Treaty 8 territory. So happy to be a part of the panel today, and thank you for inviting me. I'm just going to give a little bit of introduction to the Mikisew Cree First Nation, the nation that I'm a part of and honored to work for. We are part of Treaty number 8, and our traditional lands encompass all of the Athabasca oil sands region, so the entire region that we're talking about today. The Mikisew people, we call ourselves the people of the Delta. Today, we still actively exercise our inherent and constitutionally protected rights. We harvest off the land, including along the Athabasca River system. The Delta is our home. The Delta, the Peace Athabasca Delta, is within the Wood Buffalo National Park, also a World Heritage Site, considered to be one of the largest inland boreal freshwater deltas in the world, and really is our sacred place. We actually call it God's country. For many of you that have been to Fort Chip, my home community, will know exactly what that means. We have been, within the Delta for thousands of years. The Delta has been very good to us. It's nourished us. It's provided for us. And everything that we need has been in our Delta. Our Delta today is deteriorating, both with loss of water and also change in water quality. I'm going to be kind of explaining how the factual record, the report released just a few months ago, really didn't come as a shock to many Indigenous peoples in this region. It really affirmed, I guess, it really just was another report that really just said what our communities have been saying, for a very long time, that our environment is changing, it's deteriorating, everything is becoming polluted, and things are changing far too fast. And some of these changes could be irreversible and significantly changing our delta ecosystem. The delta, I'm going to focus just on the delta because that's downstream from a lot of the development, and also the area that we're most familiar with a lot of the deterioration and changes, which really resulted to us taking some action and filing a petition to the World Heritage Committee through UNESCO. Because the delta was situated within the World Heritage Site, and really Canada has an obligation to protect the outstanding universal value, the integrity of the delta. And so we also recognize that Canada is failing to do this. And so we raised these issues to the International World Heritage Convention, really saying Canada needs to do a better job in managing a lot of these threats outside of the delta, because we're seeing significant changes in the delta. The delta has been built from a lot of the sediment coming down from the Peace and Athabasca river systems. It's those nutrients is what built our delta over the past thousands of years, and provided, very well to the Cree and Dene people, the first peoples of that area. It was, that's where we harvest. It's one of the significant trading routes in Canada. It's fur-bearing animals, staging ground for migratory birds, abundance of wildlife. It really, really has been a very important ecosystem. And it's, today that's not the case. We hardly see birds, we hardly see moose and other important wildlife. And so a lot of those changes in terms of impacts from upstream, industrial activities is also impacting Indigenous rights and Indigenous culture, including the Mikisew Crees. So these nutrients, again, from the sediment flowing and develop the delta, are also carrying these contaminants. So what really was about building a very healthy delta ecosystem, quite some time ago, is now becoming what some members in my community say, becoming like a toilet bowl, a collection of waste. And because of the loss of water and climate change and increase in contaminants, this toilet system that they say is not flushing out a lot of these toxins anymore. It's really just collecting it. We don't have the natural phenomena of ice jams and overland flooding reaching and nourishing the delta. And so everything is becoming very stale and stagnant. And that's really affecting, the fears in the community. It's probably also worth noting that the increase in concerns and change in people's health in my community is one of their biggest fears. We have, it's been identified that there are cancer clusters, increase in autoimmune diseases, and yet, we've been raising these concerns through 7 regulatory interventions and hearings directly to UNESCO, as I mentioned, and yet we still don't see a comprehensive baseline health study. We still don't see a tailings risk assessment to understand what these tailings ponds in terms of impacts are causing to downstream Indigenous communities, such as my community, in impacts to human health. The delta is under a lot of stress. Just today, the IUCN has released another conservation World Heritage Outlook on looking at the conservation and how well the Wood Buffalo National Park is doing on the conservation. And nothing has changed since the last IUCN outlook, which says that there are significant concerns. The trajectory for the delta is in a downward spiral. It's, things are getting worse. And we see that. things are not improving. We don't see increase in more rigorous monitoring. We don't see any policies being developed to protect the Delta. We don't see any action, despite Canada, having to develop an action plan to fix a lot of the wrongs. And reporting to the World Heritage Convention again, likely that they're working on it. But we are really getting frustrated that they're just going to continue to work on it and not take any real action. So I mentioned the report didn't come as any surprise. Again, these are observations that we have been seeing for a very long time, since oil sands started in our region. Everything has been changing. Things are deteriorating. Fears are increasing. Tailings have been, I think, the largest concern for our community. The fear of a breach, the fear that it's just continuously leaking into our environment, into the foods that we eat. It's affecting our health. It's going to affect our future generations' ability to exercise their rights, affect their health. And we really expect more to be done in this regard. I'm just going to skip over this slide. I think it's probably just to add on to what Dale has mentioned, there are obligations. So Canada, yes, must take action under the Fisheries Act, but also under the duty to consult and accommodate, deal with the impacts, the cumulative impacts. To the impacts to our indigenous rights, our treaty and Aboriginal rights. And where is the honor in the crown when these impacts are continuously increasing? And I will leave this final slide. This is from one of our renowned elders in our community, Sal Martin. A few years ago, we had a water conference in our community, and "Water is Boss" was the theme, which is his quote. And this poster is from the tech hearing, no longer in play because they withdrew their application, but the hearing was held in our community, and water really was the theme in informing the regulators, informing the AER, informing proponents that water is everything, water is sacred, and water is boss. So thank you again. I will.
Great, thank you very much, Melody. So we've got a good 15 minutes remaining for discussion. So if I could ask the panelists to unmute and enable their video. There are a number of questions that have come in. Most of them are directed at particular panelists, but so I'll probably direct it to one of you. But of course, you'd all be welcome to chip in if you see something that you'd like to comment on. First question is probably directed at Jonathan, and the questioner asks: is it fair to say that to date we don't know the mixture components that may be reaching surface waters are indeed toxic? As presented, we know some components of OSPW are migrating beyond tailings containment structures, and we can differentiate OSPW from natural bitumen inputs in groundwater. However, while under investigation, we cannot currently say the toxic components within OSPW are migrating beyond tailings components.
It's a long question. But I think the meat of the question is, are the toxic components of processed water reaching the river? And I'll say, first of all, I think, Martin might want to comment on this, that from a legal perspective, I don't think it matters so much. But that's my understanding of the law, that if the OSPW is reaching the river, that's the legal starting point. Whether the amount or the concentrations of OSPW reaching the river cause a biological effect is very difficult for me to say. There are a few studies that have looked at biological effects on the river. The 2020 article that I showed you from Environment Canada indicates that at that one site, at Pond 1, that they can't discern yes or no that there is a biological effect. The fact that naphthenic acids are there, at least in the sediments or at the mouth of the tributaries, indicates that there could be a biological effect. These are the most toxic components. So from an ecotoxicological perspective, the question just becomes, how much exposure is there and how much dilution is there? Are we asking, is there an effect in the tributary? Are we asking, is there an effect in the river? It becomes a long answer to a pretty simple question, but I haven't even touched on whether there could be human effects. And so, and you think about, oh, could these chemicals actually, even though you can't detect them in the water, in the main stem Athabasca, could they concentrate in fish? And could you therefore have human health effects? Theoretically, yes. And, you know, the methods for measuring these chemicals in fish are not really perfect yet. And so there's still lots of questions and legitimate concern, I think.
I'll just add, so the Section 36 prohibition is what we call an end of pipe test. So you don't have to show adverse effects in the receiving environment. What you have to show is that a substance that's, and the Act has a definition for a deleterious fish, and essentially it's any substance that renders that fish deleterious, or renders such water deleterious to fish, right? So it always comes back to the biological processes of fish. But it's not an in situ test. You don't have to demonstrate harm in the actual receiving environment. We sort of say, you know, essentially, you know, there's a famous case referring to bunker C oil. Once it's shown that one drop of bunker C oil is deleterious to fish, then the substance is deleterious and it's caught by the prohibition in Section 36.3. You know, I think looking at the question, and I see it on the Q&A as well, you know, I think there would have to be some reason to suspect that the constituent parts of OSPW move at radically different rates. You know, then, you know, if that's the case, if that's the chemical reality, then, you know, if there's a reason to go there. But you know, and I certainly am not aware of any of those things, and I would defer to I mean, the toxicologists on that front. But to be clear, it's not necessary to show, for the purpose of Section 36.3 and the second mode in particular, that they are entering those waters, but that they may enter fish-bearing waters.
Okay, next question is probably for Dale, and it's asking you to clarify what risk assessment was done in 2018 that did not consider NAs from the ponds.
Right, so under the Canadian Environmental Protection Act, chemicals are assessed to determine whether they're considered quote unquote toxic under the law, under CEPA, under the law. And that's a combination of the concentrations that are found in the natural environment and how toxic those chemicals are. And so those are assessed both for risks to ecosystems as well as risks to human health. And when Environment and Climate Change Canada assessed naphthenic acids to determine whether there was a toxic risk, it excluded tailings ponds as a source of naphthenic acids, and only considered sources that were from the manufacturing of such acids, and therefore much smaller sources of the chemical. And so that's, I mean, to me, it's just, if you're going to assess the toxicity, you know, and in CEPA toxic really is a risk assessment. You need to consider all the major sources, of course. I wanted to also point out there are a few questions about whether, you know, do we know for sure that these chemicals are impacting? Do we know that there's toxicity? Do we know that they're, and the foundation of the Canadian Environmental Protection Act is a precautionary principle. It is cited in CEPA. And the precautionary principle essentially says that doubt is not a reason for not acting. And so the fact that naphthenic acids were assessed and that source was omitted is problematic. what Environment Climate Change Canada and Health Canada should have done is included that. But additionally, we need to be acting on toxic chemicals that are ending up in our environment, regardless of showing absolute at the end of the line impacts. We know that a lot of these chemicals will bioaccumulate and bioconcentrate up the food web. And those kinds of assessments need to be taking into account the precautionary principle. And as the breadcrumbs were laid out in the factual record, it appears pretty clear that these chemicals are ending up in the natural environment and potentially having an impact which need to be dealt with.
Thanks, Dale. So a couple of questions, probably for Paulo for initial, but I'm sure there'll be others who want to jump in. Well, one is specific to the CEC. So where to on this factual record for the CEC? And the other large question is what's been the industry response to the factual record?
So first of all, I mean, this factual record has been made publicly available to anyone who wants to download it in the 3 official languages of the CEC, in Spanish, English, and French. There's also good amounts of information on how to file a submission, what is a factual record, what is this process about, and our organization of these kind of meetings and webinars serve to the public to understand the process and to see if there is an issue that they could bring to the CEC for through a submission. So with respect to has the industry responded or reacted to the factual record? Not to on my understanding, or not to. I'm not aware of the industry trying to clarify or having a posture with respect to the factual record. This document has been, I mean, after we published on September 4, there was national press attention to this document. There were interviews, and there were even the Minister of Environment also commented on this factual record. So there has been public attention to this. The document, and even the document that the documentation that served to develop factual record, is also publicly available. So, and on the registry of the submission itself, response from Canada, our recommendation to develop the factual record and all relevant information is on the CEC registry. So all the information is there in cec.org/submissions, and you can consult and download, print, and use this information as you may need is needed.
Great. Thank you. And a question for Melody. There was a COSIA recently hosted a mine water workshop, and there was a debate or discussion around the quality of the fish as a food source. And this fellow's impression was that the video that was shown there had a fairly positive kind of outlook on fish quality and consumption. But your comments seem to imply otherwise, or what's your thinking on that?
Well, first of all, yeah, I'm very familiar with our fish camp. As it's organized by the department that I oversee, and I was actually featured in the video. The fish camp really is about showing how indigenous knowledge, Mikisew knowledge, can be incorporated in monitoring of fish. Once a year, the camp is held. It's not a comprehensive monitoring program. That's one thing that we are requesting, is something more robust in monitoring in the Delta. Our camp really focused on looking at mercury, not all the other potential toxins, potential contaminants in the region. But it is one example where, inclusion and participation and collaboration. Many of the recommendations mentioned by Dale between the government and First Nations could work together on identifying what to monitor, where to monitor, how to monitor. But the fish camp, yes, definitely does indicate that some of the fish are safe to eat because they don't have high levels of mercury.
Thank you, Melanie. And what might be the final question, and maybe we'll do a quick go around for sort of parting comments, but question probably for Martin, and it's quite general, but there's a lot of room to move here. Is the legal and regulatory framework built to make environmental accountability hard to achieve? I guess in this specific locale.
Yeah, so I think I answered a little bit in the on like typing. Certainly, I mean, the Fisheries Act is one of Canada's oldest laws, and the prohibition against deleterious substances was included actually pre-war, even actually before the First War. It evolved over time. So the short answer is no. I don't think the legal framework was built to evade anything. And again, having spent time on this factual record for the last 2 years, reading documents, reviewing documents, I will say that is my personal opinion that it can be characterized essentially as willful ignorance, essentially, I think, of some very apparent conclusions that are inconvenient. They're inconvenient for government and they're inconvenient for industry. But when we look at the pace and the twists and turns around the investigation of these issues, it has all the hallmarks of a sort of see no evil, hear no evil, speak no evil kind of approach. And that, I think, that is very problematic. And I think that's something that Canadians need to be concerned about. And that really, I think looking at some of the other questions in the Q&A, we won't get to them, but, when we talk about regulatory frameworks on a go-forward basis, I think all of that is jeopardized in the absence of trust and transparency. And what I think the factual record shows very clearly is that there would be very little basis, I think, for Canadians and for First Nations in particular downstream of these sites to have any kind of trust that these processes will be rigorous and robust.
Great, thank you, Martin. And so we come to almost the end of our time together. Just before I'll do my closeout, and then I'll leave it to the panelists to have their final sort of farewells. Thanks to you all for the presentations. We try to cover off a bit on process, a bit on science, law, the activist perspective, and the community perspective. So thanks for your questions as well. And it's a combination of those presentations and the discussion that just kind of helps everyone have a better understanding of what's going on. We will share the slides and the recording with you all by end of the day. There'll be some feedback surveys in there as well. So we take that information to heart. Please respond if you can. And now over to final farewells. Maybe we'll start with Paulo, Martin, Dale, Melody, and John.
Well, Paul, thank you very much for organizing this and putting this together. My recognition to Sustainability Network. Thanks to Jonathan Martin Oseski, Laura Hillenday, who she's in the background, but she's been very instrumental into putting this together. Dale Marshall and Melody Lapien, thank you for your contribution and your interest in the CEC. We are here open to receive your questions and your concerns over the effective enforcement of environmental law. This process is for the public, and this process allows transparency in the effective enforcement of environmental law. So we're here to serve you. Thank you very much.
Martin.
I said mine, so I'll take a pass.
Sure.
I'll just say,
go
ahead, Dale.
No, go ahead, please.
Okay, I'll just say that I've been looking at the questions and I've answered a few of them, and some are compelling. And if there's an opportunity for us to provide written answers later, I'm happy to add to it. But if anyone has questions about my presentation or the factual record, they can of course email me and copy other panelists for a very specific discussion. If you like, I'm open to that.
Yeah, I just wanted to thank everyone for tuning in, not just the organizers and co-presenters, but over 100 people that are still on right now. So thanks for your interest.
And Melody, any?
No, thank you for the invitation and including me on the panel. I just want to, re-emphasize how important this issue is to my community, to many Indigenous communities in this region, and more monitoring. I just want to stress the importance because of the whitefish, example. More monitoring is really not the only answer. I'll leave a quote that was shared with my good friend, Dr. Dave Schindler, that, really more monitoring is great. We're collecting more information, more data, but really, are we really just about writing the obituary? Is this information going to result in any kind of affirmative action and change? Because we don't want to write an obituary for our Delta and for our communities. So I'll leave it there. Thank you.
Thank you. So thanks everyone, and we hope to see you all back here soon. Take care and stay safe.
Thank you.